Welcome back. It's 9:03, and we're now going to be talking with quite a dynamic young lady. She is Mpho Raboeane, Executive Director at Ndifuna Ukwazi. Ndifuna Ukwazi.
Ndifuna,
I do
Ukwazi.
hope my pronunciation's been good, but I am getting a bit of feedback. So let me just alert the technical producer to that. Welcome. Nice to have you on the show this morning, Paul.
Good morning. Thank you for having me, Julie.
And of course, we're here to discuss something pretty important. It's the Tafelberg Constitutional Court case, a landmark in South Africa's fight for land, justice, and human rights. Now, as South Africa marks the 59th anniversary of District 6 declaration as a white group areas under apartheid, the nation confronts a critical moment in its ongoing struggle for land justice. Uh, Obviously, this includes spatial redress and human rights. And on the 11th of February, which is today as we speak, I should imagine, the Constitutional Court will hear the Tafelberg case, a pivotal legal battle with profound implications for equitable access to urban land and housing in post apartheid South Africa. How confident are you about this case at the Constitutional Court? 30 years into our democracy, looks like we haven't quite made the right moves in this direction. Welcome.
Thanks for that intro, Julie. And I think it's quite important to preface this discussion in why Tafelberg, why the case itself, and why it's so significant in the context of our history. I mean, you said it in your introduction that today marks 59 years after the implementation of the Group Areas Act, which declared a number of, cosmopolitan, multicultural areas as white-only areas. And under that law, we saw the mass forced removal of many communities of color. And the whole thing about spatial injustice is to try and redress those egregious wrongs of our past. And this is mandated in our constitution. But what we're seeing is that there has been no political will, there has been no energy, let's say, from the political class to actually use the same energy that we saw the apartheid regime using laws, using policies, using legislation to rectify the wrongs that were done in terms of land distribution and land holding. So what we're sitting with now, especially in the city of Cape Town, is a city that's still very much entrenched in spatial apartheid era planning. And what we're seeing is that the current housing policies, even post-democracies, are entrenching that apartheid spatial planning. So the whole point of a case like Tafelberg is to firstly alert the nation to the fact that business as usual cannot continue. We need to do something to structurally reform the way land use decisions are made and how we plan our cities, which means that we must be intentional about bringing the working poor, bringing people of color back into well-located areas, back into our cities, back into places of economic opportunity, and back into where the resources are. And the case around Tafelberg, its genesis was the sale of public land. Now, this piece of land is in Sea Point, which is prime property in the city of Cape Town. As you would know, if you do a quick search around property prices, I'm sure nothing in Sea Point goes for less than 20, 30 million, right? So
Astronomical, and
in
it's totally out of the reach of ordinary working class. And
exactly.
of course, this talks directly to the issue in the Western Cape. It has become a tale of two cities, has it not?
Exactly. So, what we're seeing with the property market specifically is that almost 75% of Cape Townians cannot afford to buy a house. So, if three quarters of your population cannot afford to house themselves, that should be a clear indication that there's something very wrong with the system. But what we've seen is that there's been a huge reliance on the market economy system, and rather not so much attention paid to what's been mandated in the Constitution, which is to redress that spatial injustice, the spatial apartheid that came about around 59 years ago. So Cape Town is indeed a tale of two cities, but in Sea Point specifically, what we see is that the people that keep the city going, keep that area going, and that's your domestic workers, that's your petrol attendants, that's your teachers, that's your nurses, those people who are integral to the local economy of that area cannot afford to live near where they work. This also has an impact on children. Their children cannot afford to go, or their children cannot go to those schools in those areas because they cannot afford to live there. So it has a mass impact, a knock-on impact on the inclusion and the dynamics in these communities. And that's why we're seeing the continuation of largely whites-only communities, because those are the socioeconomic groups that can afford to live in these spaces. So it's no longer a legislated apartheid. It's actually a market enforced apartheid. If you cannot afford to live there, and by virtue of our history, people who cannot afford are, black and brown, then, you're structurally left out. So what the case was about was how the province at the time, and this is 2016, decided to use its public land. And the argument here is that public land is, of course, a public resource, a common good. And that common good should be enjoyed first and foremost by the public. But what we saw in 2016 was that that administration was trying to dispose of this prime piece of land, which was quite expansive, big enough to hold several rugby fields, and big enough to enact around 270 units of social housing. They wanted to dispose that to a private buyer, basically taking such a valuable good out of the public and putting it into private hands. So now we came in at that point to try challenge the premise of that sale, because that's effectively the privatization of a very scarce resource, which is land in our country. And I'm sure, given the historical context we've just discussed, land remains a very crucial and very under discussed issue. But that is actually fundamental to the socioeconomic, the racial injustice, the economic injustice that we sit with today, 30 years into democracy. And we challenged that sale on the premise that the province didn't actually apply its mind to the existing laws that mandate the state to firstly consider whether or not any infrastructure or capital asset is indeed surplus. And what we mean by surplus is that the government no longer needs it. No department needs it. It's of no use for states running. And part of that consideration is something like basic services. Do we need this thing to ensure that we can deliver basic services to the people
Okay.
our
Mpho, let
constitution?
me come in here. We're going to have to wrap up in the next 2-3 minutes, but I digress. But I think it's also talking to the very issues you're raising here now. There's been discussions, and it has also made media headlines. The Khoi and the San people who are disputing some land which they believe is very meaningful to their culture. And I understand developers are wanting to get their hands on that land as well, somewhere in the Western Cape. I'm sure you know what I am talking about here. I can't remember exactly which piece of land, but this has been an ongoing dispute now for a while. Um, I wonder if you have any input on that matter, or are you just aware of it? Then also the issue I spoke, and I keep bringing it up whenever there's issues around land disputes, and the fact that When you talk about the Western Cape, you're talking about tale of two cities. You have the uber rich living in houses that costs nothing below 20 million rand. And then you have the indigenous people of the land who are servicing that class of people who are unable to even possibly afford a shack. What do you believe government ought to be doing? And if those housing prices on the Atlantic seaboard is going through the roof, what does it say about our future generations? Are they even going to be able to afford to live in that part of the country? So some of those thoughts and some of those questions, I think, needs a deep discussion as well.
Yeah, definitely. Um, And I think just on your point, just on your last point, that's the whole premise of the Tafelberg case. It's to try and get clarity on government's obligations around spatial redress and spatial justice. So what we're saying is that public land should be used essentially for the public good. People who live in the cities, who service the cities, should be able to access those cities in meaningful ways. And that includes being able to live in there, live in those areas without having to pay a transport tax, which takes about 40% of one's income just to get into the city and places of work. And what our concern is that should we leave the market unfettered at this rate? Like you say, the indigenous of the land won't be able to access this place. And that is essentially a second dispossession, a market driven dispossession. Um, and what does that say about a country that says in its constitution it's intentional about redressing the wrongs of the past, which includes the mass taking of land from large communities, but then turns around and sees those very same communities repeatedly displaced because they do not have a foundational thing that is access to land, the land of their birth. And that brings us to the situation. I think you're referring to the two rivers.
Yep,
Um,
absolutely. Yes. You've
that's
hit
right.
it on the nail. That's right. The Khoi and the San
That's right.
claim to that piece of land.
So that case saw its ups and downs, but essentially the dispute there was that the First Nations people who did lay legitimate claim to that land were fighting against, again, the privatization, not only now of land for people to live, access the city, but a sacred land. So
Hmm.
this now goes beyond the current needs. This speaks to posterity, but it also speaks to our history and our spiritual ancestry. And here we're seeing a situation where the city of Cape Town has again let private developers, through the company of Amazon, establish what could be considered a monstrous development, which essentially plugs the Liesbeek River, which is of huge significance again to the First Nations peoples, but also to the history of the area in terms of the first wars between the Khoi and the Dutch settlers. And what we're seeing is under the guise of job creation and progress and prosperity and economic prosperity, we've seen these nations essentially hoodwinked with respect to the raw deal that they've gotten in terms of that land. So now what's been promised there is there will be some type of monument that pays homage to the history of the place. And there will be some economic interactions with various groups of those First Nations claimants, but essentially access and the 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 sincerity of the land has been compromised. And like I said, we've seen a mass privatization across the board, which is increasingly concerning. And I think just to tie it off then, um, this is again a question that we're hoping today's case will start to answer. around who gets to access the land and how are decisions around land made, especially when it's the state in charge of a public resource. When we say that we are a democracy, when we say that we are participatory democracy, we need to make sure that decisions around land use are inclusive of our people, and we need to ensure that spatial justice is actually realized. So not only do we want to see the claimants of District 6 return to the land that's been sitting there unproductive for many, many years, we also need to see uh, Black and Brown people, people that power the city, being able to live in the areas where they contribute. And that means opening up these private, mostly exclusive neighborhoods in by way of introducing affordable housing, social housing, things that are within the normal South African
Okay.
reach.
I have to unfortunately leave it there. Are you hopeful? Short answer, please, because I have to wrap up.
I am very hopeful because justice is on our side.
Good on you. Good on you. Thank you indeed. It's been fascinating talking to you, and fingers crossed for the outcome at the courts today. That, of course, was the lovely Mpho Raboeane, Executive Director at Ndifuna, Ukwazi, talking about the Tafelberg case going to the Constitutional Court today. Much luck and success till the next time. God bless.
Thank you. Goodbye.
9:20 exactly, news and views on Salam Media. Let's go for an ad break and then we'll continue with the show.